start. Firstly, I know that you have done civil procedure. Have you touched upon the concept of mediation, alternative dispute resolution before in your civil procedure? Okay. And you know what is confidentiality and without prejudice, right? Okay. Well, since you have sort of learned about it in civil procedure, you should know that mediation and collaborative practice are what we will be covering today. It's what is on your course manual. That's why they are the main focuses of today's lecture. They are two of the forms of alternative dispute resolution. The term of alternative dispute resolution exists because we have litigation. Litigation itself, court trial, as the default form of litigation. But by now, you should know that litigation, a trial in the court, is only one way of resolving a dispute. Okay, the law, obviously, in the context of such as a criminal law, is what will govern our life. But in the civil context, the law might well be just a tool to help you resolve your disputes. Okay, it's not necessarily the default way of resolving a dispute. Okay, it's just one way of dealing with parties' disputes and conflicts. You can always settle and resolve resolve your dispute privately. You don't always have to go to court, at least in a commercial context. In a divorce, obviously if you want to be legally divorced, you want to be single again, then you have to go through the legal procedure to get divorced. But in terms of how you want to handle the divorce, how you want to deal with your finance and children arrangements, you can totally agree privately. It's just that at the end of the day, to protect your position, you want to turn your agreement into a court order. Okay? But as to the substance, you can always agree privately as long as it does not contravene the law. Okay? Family cases are different from civil cases, commercial cases in the context of alternative dispute resolution, because matrimonial disputes involve children in some cases. It involves relationships. Okay, it's personal. It can be very emotional, and it's not purely commercial, even when you're dealing with the financial aspect of a divorce. It is different from civil, a civil case that is not matrimonial, in the sense that in civil matters, it's, to me personally, it's purely a commercial decision most of the time. It's a calculation of whether a civil claim is worthy of your money, is worthy of your time, so that you continue to litigate in the court. Or in the interest of legal cost and time, you might just settle it privately. Or if you're the claimant, you think that the time and the money is not worth it, then you might as well just drop your claim. Or if you are a defendant to, say, a money claim, you might as well just pay the money to save the hassle. Okay, so you don't litigate in the court. So in that sense, that's what I mean by a civil claim. It's probably just a commercial decision. Okay? It's a matter of weighing the time and cost in litigation versus in private settlement. And the money in the civil claim, to some extent, it's separate from your life. It's something additional. So you can choose to litigate or not. But that is different in a matrimonial context. In a divorce, the divorce is part of your life, especially when you have children. Children would have a cardinal place in the case because they're your children. It's obvious. But even for the finance, it's not like in a civil claim where you just take a sum of money and then you settle the claim. For finance, you literally have to divide up your assets. if you have asset, it eat into the whole of money of what you have. Okay, and even if you don't have any assets to share, and then you perhaps you have the device of ongoing maintenance, you are still involved in some sort of financial obligation or financial relationship in going forward. You can't really take that part out of your life, whether you are the payee or the recipient of that maintenance. Okay, so because of children and also the potential financial obligation you have, the financial maintenance, matrimonial disputes, they involve relationships. They would involve relationship in the past, because you might still want to accuse of the other side of doing something really bad to you. It involves relationship in the future, and sometimes relationships you cannot abandon, okay? Such as your relationship with your ex-partner as the parent for your children. Okay? And that relationship is for life. You can't divorce your relationship with your children as a parent. If you look at a matrimonial matter through the lens of litigation, normally in a civil claim, the parties are quite engaged, and usually, if they can't settle, then they're deadlocked in a very high conflict and polarizing position. It's always about winning and losing. You always want to emphasize you have a right to do something, this and that. Okay, you always want to find the right or wrong. Okay, so that set of mentality is not very suitable in the matrimonial context, because, as I said, it involves relationship, especially relationships in going forward, and very likely you would have to work together. Okay. Unless when there are no children involved, and when you can achieve a lump sum clean break settlement in your finance, then that ongoing relationship with your ex-spouse would be very minimal. But still, that relationship, that marital relationship, it's part of your life. It's in your book, in your history. You can't just forget about it. Okay? And also, civil litigation is very costly, it's very expensive, and it's very time-consuming. It adds a lot of pressure to the parties in divorce, both financially and mentally. So that is also not very appropriate for resolving matrimonial disputes. Okay, and that's why, in my version, alternative dispute resolution, including mediation, would be ideal for resolving matrimonial conflicts or disputes instead of courtroom litigation. Okay? And this is recognized not just by social scientists, but also by the judiciary. Okay, this is also recognized by the judiciary and recognized by practitioners as well, or they should be recognized and considered highly by practitioners. Now, today we'll be just talking about mediation and collaborative practice, because that's what your course manual expects of you. There are only two forms of alternative dispute resolutions. Apart from courtroom litigation, the rest of these things are all alternative dispute resolution, including FDR and CDR. Okay, private negotiation, the third bullet point, is an option for ADR. The difference between private negotiation and mediation is largely that you don't have a mediator. Okay, but you simply deal with each other. So in a divorce, assuming there's no third party interest, it's just the husband and the wife. So it's basically two parties negotiating. it usually can happen successfully if the parties are both legally represented. Okay, so the parties are at arm length. They can negotiate with equal powers, basically. Okay? And any settlement agreement reached under these circumstances can usually deemed to be protected because you both have lawyers. Realistically, it cannot happen when it's just a husband and wife. Because when you put a husband and a wife in a room, they just fight, right? They're getting a divorce. But even when you just have one party being represented, in the other party acting in person, it's very unlikely that you can negotiate privately, because there's always a risk that the unrepresented party is being disadvantaged without legal advice. And for the party with the lawyers, it's also a bit risky if they want to do the negotiation, because the other side without lawyers can always turn their back to the agreement, saying that it's not fair to me because I didn't have a lawyer and I got pressure from the other side. Okay, so usually it would happen when both parties are legally represented. And this is suitable when the matters are quite simple and straightforward, or when both parties have lawyers and the lawyers are very experienced in the subject matter. And compared to mediation, where you have a mediator, private negotiation has the benefits of saving the cost of appointing a mediator, and you also don't have to, sometimes in private negotiation you don't have to specifically rent a venue for mediation. Although sometimes if you physically need a space, then obviously you need to rent a space. Okay? But that's more likely when you have mediation. With private negotiation, it's even more flexible than mediation. But the downside, of course, with private negotiation is that you don't have that neutral third-party mediator. Okay? And sometimes when you might get into a deadlock without that neutral person to get you back on track, and then the negotiation might fail very easily when you don't have that middleman. Okay? For FDR and CDR, we haven't done FDR, but we have done CDR. This is mandatory by the practice direction. They are, in my personal understanding, they're quite similar to mediation in the sense that the judge would act in a capacity somewhat like a mediator, okay, who would want to help you settle. The difference is that the judge can be more active in giving some indication in terms of law. Whereas, as you will learn later, a mediator cannot give any legal advice. Okay. Strategically, one of the benefits of an FDR, especially a CDR, is that the judge would drop hints on how a judge would see the matter if it proceeds to the trial. Especially in the CDR. Remember, the CDR judge is also the judge on the trial on children matter. Okay, that's another difference between CDR, FDR, and mediation. They are alternative dispute resolution in the sense that you don't fight and then have a judgment on you, but they are mandated as a matter of court procedure. But in nature, they are a form of ADR. Okay. And also in mediation, you are bound by a mediation agreement which would inevitably contain a clause of confidentiality, and you can't disclose anything in mediation, and you can't even disclose that to the court. So the best you can tell a judge about mediation is that you have attempted at mediation, but it has failed. You can't review the offers or counter offers you have given or received in a mediation. You can't review anything you have heard or seen, or any persons you have seen in a mediation. to a judge. Okay, that's how far the umbrella of confidentiality reaches in mediation setting. But for CDR, if you recall, you can tell everything to the judge. There is no such thing as without prejudice or confidential in children matters, except what has happened in a mediation. Okay, remember that? And the judge would be the trial judge. Whereas for the FDR, this is probably new to you because it will happen next class. In an FDR, the judge can see all the previous without prejudice offers or any open offers, but again, he can't hear or see or know any of the offers or counter offers made in a mediation. Okay, and after, if a FDR fails, then there will be a new judge assigned to adjudicate the finance at the trial. Okay, but you can't, none of these can override the mediation unless all of the parties agree to review that part, which is protected by confidentiality. Okay, and there's also this thing called private FDR. So FDR is mandated by practice direction. Instead of doing it in court, you can have private FDR. So where you can find a private FDR judge, such as Justice Hartman. I've introduced some of his judgments to you in this course. And our former CJ, Geoffrey Ma, and also Judge Bruno Chan, whom I think has retired from the judiciary. The attraction of a private FDR compared to a courtroom FDR is that it's very quick. You don't have to wait for a court date, and you get to choose, you get to nominate the judge you have for an FDR. And all of these judges, there are only a few. Justice Hartman, former CJ Geoffrey Ma, and Judge Bruno Chan, former Judge Bruno Chan, are all very experienced judges in the domain of family law. So in a sense, they are better than a mediator if you want to settle privately and if you want a third person to help with your settlement. And if you fail a private FDR, you can still do a FDR in the court. Okay, they're two separate things. And I think the downside of a private FDR is that they're very expensive. Okay, there have been only a few occasions where the parties have elected to do private FDR, and I think they're all big money cases. Okay, this is not very common, but something for your interest, that private FDR can be arranged apart from the court-mandated FDR procedure. Okay. So mediation, by the definition of the Center for Effective Dispute Resolution, which is an international dispute resolution center based in London, mediation is a flexible process conducted confidentially in which a neutral person, that's the mediator, actively assists parties in working towards a negotiated agreement of a dispute or difference, with the parties in ultimate control of the decision to settle and the terms of resolution. So it involves a neutral third party to facilitate the negotiation, the mediator. It's flexible. You don't have to do it in court. You can do it in any places, in any appropriate setting, in any time. And the parties are in full control of this whole process. Okay, and you don't have to follow what happens as within the judiciary. You don't have to observe the strict rules and laws and the procedures. It's flexible in that sense. And for that reason, mediation can be much quicker. You don't have to wait for a court date, and it can be less expensive because you don't have to adjourn and adjourn and adjourn and adjourn and prepare for documents. Okay, it's confidential, as I said, and normally before the start of a mediation session, the parties the lawyers and the mediators and any person who is present physically at the mediation would have to sign a mediation agreement, which, as I said, would definitely contain a confidentiality clause. You can't review anything that has happened in a mediation. Okay. I've done a civil case during my pupillage before. It was a personal injury claim. It was a matrimonial. There have been a mediation session. The problem is that we represent the claimant for the personal injury who has suffered the injury, and he was illiterate. He can't read and he can't speak English, but as a human being, you can see a person and recognize somebody's face. One of the difficulties we had is to establish the defendant was the tortfeasor. And in our affirmation, we had difficulties in saying, in connecting the dots that leads you to the conclusion that the defendant, that company is the right defendant for their claim. Our client, he got injured in a warehouse in Yuen Long. He can't tell the address. He can't write. He can't read. The only thing he remembers is in his head a visual map of how he would get there. He can't even describe to us how he got there, but he knows. And one of the things, the case is over now, so I can tell you, they had a mediation, and the boss who appeared at the trial actually attended the mediation. So our client recognized that that guy is the right guy to sue. And he's the guy that we end up suing. But we can't adduce that evidence in court, saying that that guy is the defendant, because it's a person the claimant has seen in the mediation. We can't even review that to a judge. Okay, that's how far the protection of confidentiality will go. There is also the mediation ordinance, which you should be aware of, and there is a slightly different definition here, that mediation is a structured process comprising one or more sessions in which one or more impartial individuals, without adjudicating a dispute or any aspect of it, assist the parties to the dispute to do any or all of the following: to identify the issues in dispute, to explore and generate options, to communicate with one another, and to reach an agreement regarding the resolution of the whole or part of the disputes. So mediation is flexible also in the sense that you can have one session or more sessions, as each case might require. The mediator is just to assist, but not to make judgment or adjudicate on anything. The function of a mediation is to generate options and to communicate, to encourage communication, and to help the parties reach an agreement. It is also process-based instead of result-oriented, in a sense that a lot of the work of mediation is in the course of the mediation, and you're not looking to win. It's in the process. You're not looking at the end result of winning. The goal is not to win, but to find consensus, to find mutual agreement instead. And the parties are highly involved in this process. They have more say in this process. Mediation is not counseling. Okay? Mediation is for the purpose of finding a practical solution, to find a way out. It's not for counseling. It's not arbitration. You don't have adjudication by the mediator. The mediator is just to assist as a neutral party, not to judge. And because you have a mediator, it's different from negotiation. Okay? Or unassisted negotiation, to be more precise. and it's definitely not for giving legal advice. The mediator cannot give legal advice to any of the parties. The role is to help the parties to find a solution. Now, if you compare mediation with litigation, mediation focuses on developing mutually beneficial agreements based on the interest of the disputant. Interest can include needs, desires, concerns, fears that are important to each side of the parties. And interests are the underlying reasons why people become involved in conflicts. So that's why you look into the needs and interest and find common ground and make proposals that will satisfy the actual needs and interest of the parties. Whereas in litigation, you look at positions. Okay, you do things strictly in accordance with the law. You firstly find out what law is available to assist your position, and you argue your case based on the law. And in this process, you keep emphasizing that you have the right, and then you are correct in the law. But the problem with litigation is that the law does not necessarily address your actual needs. Okay. In a mediation I have done in a family case, we acted for the mother. It's for mediation on children matter. The mother has suffered domestic violence during the marriage, and she fears for any potential violence from the husband against the girl. But in fact, I think objectively speaking, there is no actual evidence of domestic violence on the girls. But then the mother was still very worried. She can't overcome the fear inside of her because she has actually suffered domestic violence herself. So this thing, if you bring this argument to the court because there is no actual evidence, then the judge would simply say that there is no case of domestic violence against girls. But this can be explored and addressed. Perhaps the feelings, the fears can be lessened in mediation. Okay, if we take it step by step and probe into that feelings of the mother. The basis of mediation is consensual. It's for reaching an agreement. The result is, it should be, if you reach an agreement, the result should be something that everybody's happy with to a certain extent. It is collaborative, and it takes the efforts of the parties. The parties are the key players, they agree on whatever they want. Whereas the basis of litigation is adjudicative. There is inevitably a judgment in favor of one side, and even that winning party might not be happy with the result. The whole process is adversarial. There is a winner, there is a loser. And with due process, the litigants would have to defer the whole process to legal rules, procedures, and other form of strict law. Mediation is private. It protects privacy, it protects private feelings as well, and it's also an occasion where you can explore your private needs. For litigation, in general, they're open. In most of the civil matters and criminal matters, they are open to the public. Everybody can sit and hear your case. Now, in divorce, only the main suit and certain enforcement proceedings will be done in the public. The finance and the children matters would be adjudicated in chambers, so in private. Only the parties can know. But even though they are in chambers, there will still be a judgment if you fight in a trial, and there must be, in the judgment, there must be some sound reasoning that the decision is based on to reflect open justice. So And also the judgment might be published. And even though other people would not know that you are the party to that divorce, you would know that. And some people might feel uneasy about it, knowing that your whole divorce is published for the whole world to know, even though the name of the parties are abbreviated. Okay? Mediation is an option. It's one way of resolving the conflicts. It's not automatic. And all the parties would have to agree to have mediation before you get to mediate. With litigation, it's something provided under the law. Again, it is one option, but it is the default option that people go to. And obviously, you can always sue somebody and commence court proceedings without the consent of the other party. But for mediation, all parties have to agree to have mediation. For mediation, it's private, there is not court procedure, you don't have to observe any evidential rules. You can have very flexible procedure. You don't have a fixed time, you don't have a fixed place, as in litigation. And you don't want to emphasize on legal points. You can, but normally it's not conducive. So instead, you should emphasize on your needs and your interest. And sometimes, especially when the law is not on your side, then obviously you want to emphasize the law. And sometimes your feelings are beyond the boundary, the limit of the law. And you can explore that, and that is allowed in mediation. Whereas in courtroom litigation, when you have a trial, you are bound to observe the law and the procedure. Otherwise, you'll be punished, such as by costs. Okay? And a lot of times, if you follow the law, your feelings don't matter. For instance, in finance, you can accuse the other parties of non-financial conduct, such as adultery, whatever. The standard, remember, is gross and obvious. You might have very strong feelings about the misconduct of your husband or your wife, but at the end of the day, it might not weigh in so much in the division of assets, remember? So in that sense, your feelings don't really matter. And the standard is gross and obvious. It's not a moral judgment, okay? The way that a judge would see the conduct is different from the way that you would see it as a former spouse. So in that sense, your feelings don't matter. But you can allege all those things in the mediation if you want. And in the end, for mediation, you can have a tailor-made outcome. It's tailor-made, not tailored-made. There is a typo here. Through mediation, you can have a result that you might not be able to achieve in litigation. For instance, if you have a child who is now, say, 35, if you want to make financial provision to that child, you can't ask for it in court. The court has no power to make that financial maintenance to a child at 35. Unless you can successfully argue that the child is still receiving education or training, remember the exception, and then it's fair to make that provision. But you have to argue. Whereas in mediation, you can agree to provide for anybody, actually, in a divorce. Okay. That's how I interpret the differences between mediation and litigation. They might be useful for your exams. Okay, but I don't have the full script here. It's for your interpretation and your understanding as well. There might be a question on these sort of things in your exam. There are 4 models of mediation. You have the settlement model, which is intended to encourage incremental moves towards a compromise. Okay, so it's process-based because it's incremental. You take step by step, and the ultimate aim is to settle the dispute. The second model is facilitative. which focuses on the parties' underlying needs and interests, including mutual interest. So in this process, you're trying to identify the underlying needs of both parties, and importantly, you want to find common grounds. Okay, and that's how you can have a settlement between the parties. The third model is therapeutic. It addresses the underlying issues at the heart of the parties' dispute. Okay? So this is about going straight to the core of the matter. It might not be legal, but it can be about emotional, the underlying issue. The fourth model is evaluative. It is to identify the range of settlement, in part relying on the expertise of the mediator to evaluate the problem. So this is about creativity and possibility in the mediation setting. To me, a dynamic, constructive mediation session, at least in family cases, would involve all of these four models in one mediation at different stages. But of course, it would depend on the style of the mediator, and also it depends on the progresses of the mediation as well. Okay. The role of the mediator, as I've said a few times already, is to facilitate, is not to adjudicate, not to make judgment. The mediator has to be impartial and neutral. He's not for or against any of the parties. He sits right in the middle. He's not supposed to be judgmental. And he is also bound by confidentiality. He would also sign on the mediation agreement, which contains confidentiality. So what a mediator actually does in conducting a mediation, he would firstly draft a mediation agreement. In this process, he would identify, well, at the beginning, he would seek to identify and prioritize the issues. He would identify and put emphasis on the needs and interest, okay, and direct the parties away from positions, legal positions or legal rights. In this process, the mediator would also identify the common grounds. He would also propose some possible solutions to the parties to help with the settlement. Again, he's not to give legal advice. Okay? And a mediator doesn't have to be a qualified lawyer. Okay? It's a separate profession. A lot of the mediators are lawyers. A lot of them are solicitors or barristers. So you have, if a lawyer becomes a mediator, he or she has to be aware of that natural instinct, that tendency to go into the legal aspect of things. Okay, it's not necessary, and in fact, I don't think the legal aspect in most cases, in most situations, would be helpful. It's better to leave the law behind in a mediation session. Okay, the mediator also has the power to terminate a mediation session at any time. So do the parties. In the end, if you reach an agreement, a partial agreement or agreement of the whole dispute, the mediator can also help draft an agreement, or if you have lawyers and the lawyers help you draft the agreement, the mediator can also help you finalize the agreement. What the mediator would not do is to draft a consent summons or consent orders. That's the job for the parties or the parties' legal representatives. Okay. And to do a good job in mediating, a mediator has to understand the parties' needs and to translate and to reframe their needs and expectations, which I hope I would do some demonstration of in our mock mediation. and the mediators would explore rigidity. Some mediators are really practical. To explore rigidity means that when parties are in a deadlock, instead of avoiding that problem, I think a good mediator would go straight to that deadlock and to brainstorm. And in this process, a mediator would reinforce movement in negotiation. You don't want to get to a dead end and then you find no way out. Because when you reach that stage, you might as well just terminate the mediation session. And in this whole process, in the mediation, the mediator will find different ways to place values on agreement. Some mediators, they would be very proactive, and instead of staying with the parties' respective argument of their case, the mediators would try to brainstorm different scenarios. They think out of the box. And so that they in that way, they encourage the parties to focus on resolving the conflicts, resolving the conflicts and finding solutions instead of the conflicts themselves. Some mediators, I've seen an example. They like to tell stories of different things that have happened with their previous cases, previous mediations, just to help ease the atmosphere so that it's more relaxing for the parties, and then they're more willing to participate in this process. Okay? Because mediation is process-based. It involves the parties' active, collaborative effort. So, before a mediation can actually take place, you would usually have an intake session first. What happens in an intake session is that a party will see the mediator privately without the other side. And then the party would tell the mediator briefly about their case, their wishes, their expectations, and perhaps their proposals. And the mediator would then assess whether the case is suitable for mediation, and the mediator can start preparing for the mediation. And before when a mediation is suitable at a certain stage, then you should prepare a information package. What it means is basically the relevant papers you have, court papers, papers on the background of the case, and perhaps you would also draft a list of issues, and you would also send out previous offers, be it without prejudice offers or open offers. You would send all these things to the mediator. It's kind of like preparing for court proceedings where you will have court bundles. Okay, so you send all these relevant information to the mediator, and then this is purely administrative. The mediator would confirm the session, the date, and the venue. The venue can be very flexible. It can be done in a mediation center. You can rent that. There are different centers offer that sort of facilities. And you can also do it in conference rooms in a law firm, provided that you have at least 2 rooms. Okay. In a divorce, because you're a husband and a wife, if there is no third-party interest, you will need 2 rooms only. So you can have a room where you can talk to the mediator privately, or where you can consult your lawyers privately. And then one of the rooms can be used for joint session. Okay, so 2 rooms would be good enough, and if you are really resourceful, you can have 3, where you can have a individual room for the joint session. Okay, but that's a little bit wasteful. It's not very necessary. The point is that you have that physical space to protect your privacy and confidentiality. Okay. And perhaps for the parties, for the lawyers, you have to assess for disputes on finance, you have to assess whether the financial disclosure is sufficient so that it's appropriate to have mediation at that stage. For mediation on financial matters, you want some basic disclosure, such as Form E, the finance form, with some bank statements, so you have some basis, a rough basis for the mediation. But at the same time, you don't want too much information on the finance, because if you have spent so much time and energy and cost on discovery already, you might as well just go to court. You don't have the incentive to do mediation. And also, when you have more and more evidence, there will only be more and more accusations and suspicions. Then the parties tend to get more emotional, so they are also less willing to settle. And that's why you want to limit the documents. Okay. You should know that mediation is not an occasion for fishing. So the mediator has to be very careful in controlling the mediation. If a party is fishing, the mediator should find a way to take the party back to the need of settlement, to finding solution. Okay. In a mediation, you're very likely to start with a joint meeting. This is usually the case in a civil or a commercial matter. For family, I don't think a joint session as a start is necessary. There is no need to have a joint session at the beginning, especially when the case is well prepared by both parties and the parties are represented by experienced lawyers. But for the demonstration today, I will follow this format, just so that you have that framework, that structure in your head. With a joint session, the first thing you do for the parties is actually the parties, the lawyers, and the mediator will have to sign on the mediation agreement. The mediator would then provide an opening statement. He would introduce himself, the parties, and the background of the case. The parties would then have the opportunities to present their views, their needs, their goals, expectations, and perhaps legal issues if you wish. Again, if you have lawyers representing you in mediation, lawyers have a tendency to make legal submissions, to make legal points. I personally don't like that. It's not very constructive. So instead, I might, even if I go to mediation with my client, I might ask my clients to start expressing their wishes, their feelings, and perhaps I would do the part of summarizing the main points. Okay, and the mediator would offer a summary after each party's presentation and identify the areas of agreement and disagreement and to set out the agenda of the mediation. So the mediator would repeat what the parties just said in their respective opening, but the mediator would usually rephrase them to narrow down the issues and also help the parties to see the issue in the light of settlement. Okay. Instead of emphasizing the positions and rights. And then you can proceed to private session where the mediator would meet with a party in private. And that private session is called a caucus. Okay? And in that caucus, the mediator would explore the parties' views, wishes, and proposals in greater details, confidential and not known to the other side. And the mediator can also, in this process, brainstorm and propose possible solutions, okay, counter offers. And then the mediator would meet with the other party and do the same thing. And you can have a few joint sessions and private sessions. It depends. It depends on the progress. In the end, if you have reached a settlement, then you would draft a settlement agreement, or sometimes it is in the form of memorandum of understanding, and then a consent order would be drafted accordingly, that it reflects the settlement. But that part, the consent order, is not drafted by the mediator, it's by your own lawyers. If there is no settlement, then you have to report back to the court saying that the mediation has failed. If there are some progresses, you haven't reached an agreement, but you are likely to reach an agreement, and you need to arrange for a further session, then you should also inform the court, okay, so that you can vacate any imminent hearings to keep the mediation going. So by now, I hope that you have already have some ideas of the pros and cons of mediation. Mediation is cost saving, it's cheaper, it's quick, it's for mutually satisfactory outcomes based on needs. You can find resolutions beyond legal issues. It usually has high client satisfaction. It controls risks, litigation risks. It's less stressful, and it preserves the dignity of the parties. And that is because if you can settle privately, be it in mediation or otherwise, you don't have to endure the trial, you don't have to go to the witness box, you don't have to be cross-examined by the other side. Now think about this in a divorce setting. The cross-examination from your ex-wife or your ex-husband's lawyers, they can be very, very nasty. And it's all about your private life, and it's not a good experience. It never is. Okay? So if you can settle in mediation, you don't have to go through any of that. And of course, mediation looks to future relationship. So it saves you the chance of cooperating with the other party in the future. Disadvantages, as with any private settlement, there is no guaranteed outcome. So you might have spent the time and money on mediation, and then it fails, and you go back to courtroom litigation, okay? And you might be back to ground zero. Okay? There's probably no progress at all. And also with mediation, you might argue that there are inadequate safeguards. You may find out later that if you have settled, then you might somehow find out that you might be able to achieve more than what you have got in mediation, or your lawyers might have lost sight of some legal points, so that you have get less now with mediation. But that's the whole point of having ADR, including mediation, is to forget about your legal positions, forget about the right. It's for moving on, and you don't want to keep thinking about what is right or wrong, or what is your legal rights. Okay, it would drive you crazy, especially in a divorce. In terms of cost, now normally it would be more expensive to go through the whole court procedure and then to fight the case in a trial. But if you don't engage lawyers, then there is no concern on legal cost, at least for your lawyers, okay? Because you go in person, you don't hire lawyers. But for mediation, at the very least, you will have to pay for the mediator and perhaps the booking of some rooms in the mediation center. And usually you split their fees with the other side. So in mediation, you would in fact incur some costs. Okay, but if you have lawyers, usually it's more expensive to litigate than to mediate. There is a practice direction 15.10 on family mediation. The objective is to facilitate the settlement of the dispute, and the court has the duty of helping the parties to settle their case. The parties and their legal representatives also have the duty of assisting the court to discharge that duty. So the parties, it's not just a duty of the court. The parties also have a duty to consider and use their best endeavors to mediate. And the lawyers also have a duty to facilitate settlement. Even though they would normally make more money if they push their clients to fight in a trial, they have duty to encourage settlement. Okay, on costs, in the end of a litigation, when deciding on cost, the court will look at all the relevant considerations, including any unreasonable failure of a party to engage in mediation. Okay. And the legal representatives need to advise the clients on the possibilities of an adverse cost order if the party unreasonably fails to engage in mediation. And at the very least, as per paragraph 1.5, the guidance is that as a litigant, you would at least have to engage in mediation to the minimal level of participation. Okay? And if you refuse to have mediation, you need to give reasonable explanation for it if you don't want to have mediation. In practice, because of this rule, and just to safeguard your cost position, the parties would 90% do the mediation. Most of them might just want to go through the motion, especially at the beginning, because of this rule. Okay. It's hard to justify if you don't go to mediation. I think this practice direction, the relevant parts of it, have been extracted and included in your course manual, so I won't read it word by word. Part 2 and Part 3 of this practice direction is about the certificate as to family mediation, which we have covered when we talked about petition, when we talked about the divorce. If the parties indicate that they want to attend family mediation, the register with that document would refer your case to the court coordinator. And as I understand, the court do not have the facilities or court mediators to conduct mediation for you. What they would do is that there is a center in the family court, in the district court level. They will give you some leaflets. They will have a meeting with you and tell you about mediation, the pros and cons of mediation. So it's like a briefing session that encourages you to do mediation for settling your divorce. Okay. And you can read about the procedure in your course manual. If you are in the course of planning for or continuing mediation, you should tell the court about it. There is no automatic stay of the court proceedings, so you have to apply for stay. Especially if you have a hearing on some substantive disputes coming up, you don't want to, as a lawyer, you don't want to send a message to a client saying that even if you fail to settle in the mediation, you can still fight in court. In that case, your client would have very little incentive to settle in the mediation. They would just go through the motion in mediation. So in that sense, you basically waste your money for mediation. So then you should, in this situation, you should apply to adjourn the court hearing to a further date, which is usually months away, or you apply to adjourn the case sine die to a date to be determined. Okay, you adjourn the hearing. You don't want to have a mediation and then a substantive hearing next week. It doesn't help the mediation. And if you agree to mediate, but you can't agree on the relevant arrangement for that upcoming mediation, you can apply for court direction under Part 4 of this practice direction. If you fail to settle, you have to report to the court that you have failed to settle. If you have reached an agreement or partial agreement, you should draft a consent summons reflecting the settlement for the court to consider and to turn into an order by consent. That's how you secure your agreement. Okay? If you don't apply for the agreement to be turned into an order, the agreement is at best a contract, which might not be binding at the end of the day, but a court order is binding. So you have to, if you have an agreement, remember to put it in the form of a consent summons, and then the court would have the power to make terms in terms of the consent summons, okay, by a consent order. Okay, so that's about it on mediation. There are only a few slides on collaborative practice. Can I keep you for another 10-15 minutes, and then we can just finish the lecture in one go, and then we have a break. Now I have to tell you that this thing, I have never heard anyone do this, and I will tell you why later. So I can't give you an example on collaborative practice, okay? But you have to know, just so you have an idea of what it is, it's in your course manual, okay? Collaborative practice, or sometimes it's called collaborative law practice, is a legal process where a married couple who have decided to separate or end their marriage work with their lawyers with the intention to avoid courtroom litigation and achieve a settlement that best accommodates the specific needs of the parties and their children. So it's very similar to a mediation, but it has even greater emphasis on the settlement, and it's for a married couple, so it's only for matrimonial context. Okay, it's a roundtable negotiation, and you don't have what you call the legal professional privilege. Okay, everything is on the table, and you agree to settle the disputes in a negotiation style. There is an agreement between the parties and the trained professional representatives, such as their lawyers, to act collaboratively to resolve any matrimonial dispute and not to litigate. The trained professional representatives can include forensic accountants, collaborative trained forensic accountants on financial matters. They can also be child psychologists. Okay, they are also collaborative trained. You can have all these experts on this list. And upon failure of this collaborative practice session, these professionals involved are precluded from representing the parties in any future litigation in court. This is a salient feature of collaborative practice. You don't have that in mediation. So following a collaborative practice, if the case proceeds to courtroom litigation, then the parties would have to start afresh with new lawyers, new experts. And that's why in practice, no lawyers would have the incentive to do collaborative practice. Because if I do it, then I would have to turn down a potentially very lucrative case. Okay, I can't continue to represent the clients if this practice fails. Okay, you turn down businesses basically. The objective of collaborative practice is to build settlement on areas of agreement, and to achieve that, there are some behavioral requirements to be observed by practitioners. Okay. They should avoid the use of inflammatory language. They should focus on what is important to the parties themselves, their needs. They should conduct negotiations in a constructive and non-confrontational way. They should ensure that the clients put the best interest of the child first, and to ensure that the parties understand the benefit to the children if parents can cooperate over their care and upbringing rather than to seek access, custody, and control. Okay, focus on the welfare of the children instead of parental rights. Okay. The practitioners should also ensure that all the parties are open and honest in all dealings. They should retain professional objectivity and respect for everyone. They should take into account the long-term consequences of actions and communications, as well as short-term implications. They should keep the financial and children issues separate. They should ensure flexibility and control, allowing parties to move at their own pace. So in other words, it's collaborative, it's process-based. They should ensure that consideration is given to balancing the benefits of the agreement against the likely cost of appointing a new team to conduct litigation. Okay. Now, so the first thing you have to remember is that agreement, which bars everybody from continuing to represent the client in going forward if the collaborative practice session fails. It actually gives the pressures and the incentives for the parties to settle at the collaborative practice. Okay, it's very different from a mediation agreement. The second salient feature of collaborative practice is that there is strong emphasis on listening to the children. So in a collaborative practice session, you may hear the views of a child directly, but of course, subject to the child's age, emotional maturity, and willingness of participation. Or you may invite impartial comments from a child's teacher, psychologist, or family doctor. So the children are very involved, and you can also have all the other relevant parties involved in relation to the interest of the children. This is very different from litigation, and also very different from mediation. It's very unlikely that a child will be present at a mediation session, okay, even though the dispute might concern the interest of a child. And this part of listening to the children is to reflect Article 12 of the United Nations Convention on the Rights of the Children, which provides for the right of a child to express their views freely, to be heard, and to have their views given due regard in accordance with the age and the maturity of the child in any matters affecting that child. Okay, this is just my summary of the convention. It's not the original text. Okay, this is the part of the collaborative practice, short and sweet. I think this is also reflective of the materials you have in your course manual, just so that you are aware of this mechanism and this practice. It is, from what I've read in reference book for practitioners, it's quite popular in America and in Canada, but is not so popular in Hong Kong. Mainly because it's very, it's not that attractive commercially. And we also have other devices such as mediation and private negotiation for the sake of settlement. So perhaps there is no need to go to collaborative practice. Okay? So that's the lecture on mediation and collaborative practice. How about we come back at, do you want 20 minutes or 15? 15 minutes, so 5 to 9. 8:55. Okay. Last time I explained to you how I did the calculation for the wife's proposals and husband's proposals. Do you want me to go through it again before we do it, if it's not very clear to you? Do you need that? Okay. It's not examinable, but if you're interested, I can do it again. Or I can do it during the break if you want. One thing that I wish to clarify is that if you remember, if you don't, then it's fine. Last time I mentioned about reestablishment and how you can calculate that part based on needs. I made a mistake in maths because I overlooked a zero. So if you remember vaguely the part on reestablishment, just forget about it. Okay, I made a mistake in maths, in calculation. If you remember, so in your worksheet, the factual scenario, you will see that the wife is asking for 60 million, the husband is asking for 20 million, and I said last time the reasonable range should be something in the region of 30 million. Remember that? If you look at the needs of the wife, and by the way, 30 million is less than half of the matrimonial pot. However big you make the size of the pot, or however small. Okay. But if you look at, I've done the calculation on the needs of the wife, it amounted to 30 something million. If you maintain the wife for life. But that part, so that's a calculation looking at the needs of the wife, and that is less than half of the pot. Okay? Whether you adopt the husband's case of the size of the pot or the wife's case on the size of the pot. So the point is, sharing is almost always better than looking at the needs. You always achieve more if you are the claimant, if you apply sharing. Okay? But if you are curious about my calculation on reestablishment, that was mistaken. I'm sorry. Forget about it. Okay. Okay. Sorry. Come back at 9. Okay. If you want to know about the calculation, I can do it during the break for you.